Rights obligation of a citizen. Section 1 to Section 9. CPC provides the suit in which right to property or office is contested is a suit of a civil nature. Notwithstanding, the such right may depend entirely on the decision of question as to religious rites, ceremonies. Strikes should be called only if at least 15% of workers are in support of strike. Strike should be called only if at least an industrial establishment. An industrial establishment means factory, mine, plantation. Industrial establishment, factory, mine, plantation. What is the time limit under section 468 CRPC for taking cognizance? Under section 468, 3 years. Under section 462, limitation shall be CPC for the taking cognizance, 3 years time limit. Cognizance, 6 months if the offence is punishable with fine only. 1 year if the offence punishable with imprisonment for term not exceeding 1 year. 3 years if the offence punishable with imprisonment and for term exceeding 1 year but not exceeding 3 years. Adam Smith has enumerated canons of taxation which are accepted universally. They are equality, certainty, convenience, and economy. The first time in India income tax law was introduced by Sir James Wilson in the year 1860. Sir James Wilson in the year. First time in India income tax law was introduced by Sir James Wilson, 1860. Which one of the following section of CRPC deals with compundable offence? Section 320. Section 320. For the time limit under section 468 for taking cognizance, 3 years. 468 for CRPC for taking cognizance. Section 468 of 89 CPC 1908 mini trial. Section 89 of CPC empowers the civil courts to refer matters to alternate dispute resolution. Methods, arbitration, conciliation, and judicial settlement, including local adalat and mediation. For the maximum number of conciliators allowed in conciliation proceedings, maximum 5 conciliator. Section 64 of Arbitration of Conciliation Act 1996 deals with the appointment of the conciliators. It provides that when the invitation to the conciliations is accepted by the other party have to agree on the composition of the conciliation tribunal. In the absence of any agreement to the contrary, what is status of settlement agreement in conciliation proceedings? Actually, same as settlement award. What is status of settlement agreement in conciliation proceeding? Same as a settlement award. Section 73 of the Arbitration of Conciliation Act. Settlement agreements. Section 73. Section 64. Arbitrations. Under section 118 of the Indian Evidence Act, person is competent witness if he or she witness competent witness is capable of understanding question put to him and giving rational answers irrespective of age. Is capable of understanding question put to him, giving rational answers. Section 18 of the Indian Evidence Act. All persons shall be competent to testify unless the court considers that they are prevented from understanding the question. Is the following judgment is irrelevant under section 43 of Indian Evidence Act. Judgment of criminal court. The following judgment is irrelevant under section 43. Judgment of a criminal court. Judgment of a criminal court. Section 40. Section 40 to section 44 of Indian Evidence Act 1872 lays down the provision related to judgment of a court of justice when relevant. Section 40 deals with the previous judgment to bar a suit or trial. Section 41 deals with the relevance of certain judgment in probate it is judicial. Relevance and effect of judgment. Under Section 43 of Indian Evidence Act, judgment of criminal court, under which sections of the Indian Evidence Act witness has been right to refresh his memory. Section 159 given right to refresh his memory. Under section 159 Indian Evidence Act, a witness has been given right to refresh his memory. Under section 159 Indian Evidence Act, a witness has been given right to refresh his memory. Section 159 enables a witness referring to the following documents. Right to refresh his memory, witness. It's the time of transaction concerning professional trades if the witness is an expert. Such writings any such writings made by any other persons and read by a witness within the time of aforesaid. Professional treatise. Mandamus may be issued by the Supreme Court and High Court. The provision for administration tribunal added by Administration Tribunal, 42nd Amendment. Provision relating to free legal aid is given under Section 304, free legal aid. Legal aid to be accused or state cost. Under which one of the following provision of CRPC, police officer is under an obligation to produce the person arrested before a magistrate within 24 hours of the arrest? Under which of the following provision of CRPC, police officer is under an obligation to produce the person arrested before a magistrate? Section 57. Provision of Administration Tribunal added by 42nd Amendment. Administrative Tribunal. Free legal aid given under 304, Section 304 CRPC. Free legal aid 304 CRPC. Under the dissolution of the Muslim marriage 1939, a Muslim wife can seek dissolution of marriage if the husband fails to perform marital obligations. Marital obligations, 3 years of marriage. The concept of curative petition was introduced by the Supreme Court of India in the case of curative Rupa Asakhura Asakhura. Rupa Asakhura Asakhura. Right to free legal aid was recognized as a fundamental right under Article 21 of the Indian Constitution in the case free legal aid. This question was added. Free legal aid 29 fundamental rights under Article 21 of Indian Constitution in the case of free legal right to free legal aid. Section 66 unconstitutional in the case of Shreyas Singhal versus Union of India. Information Technology Act was held unconstitutional in the case of Shreyas Singhal versus Union of India. Supreme Court has struck down Section 66A Information Technology Act 2000 as unconstitutional on ground of violating the freedom of speech. Freedom of speech guaranteed under the Article 91A of the Constitution of India. Provision of the Section 66 Information Technology Act. Punishment for sending offensive messages through communication service. A teacher is not workman within the purview of industrial disputes. A teacher is not a workman within the purview of industrial disputes. Sundarambal versus Government of Goa. Sundarambal. Sundarambal, Government of India. Sundarambal school teacher whose service were terminated. Teacher is not workman within the purview of industrial disputes. By management raised in industrial dispute under the Industrial Dispute Act. The Supreme Court in the appeal by special leave before it which dismissing the appeal against the judgment of High Courts held that even though education institution has to be treated as an industry, the teachers employed by education institution, whether they said primary, secondary, graduate or postgraduate, education cannot be called as workmen. Section 2. Teacher is not a workman. According to Factories Act. According to Factories Act, a child means a person who has not completed his 15th year of age. 15th. To see of the Factories Act 1948, define child as a person who has not completed his 15th year of age. Unsettled model law rules don't become part of the arbitration act so as to become an aid to construe. Unsettled model. Union of India versus East Coast Board Builders. Engineer Limited. Arbitration Act so as to become an aid. Waiver of right to object deviance from arbitration agreement is mentioned under of section 4. Section 4.